My name is Patricia Cummings, and I am the Chief Prosecutor in the Conviction Integrity Unit here at the Dallas DA's office. Probably the most fair assessment and short assessment for purposes of this is to say that what we do is we take a look at cases where a person has been convicted, but there is now a claim that the person was wrongfully convicted, and there's some new evidence indicating that they might be legally actually innocent. The case that I would like to discuss a little bit about in terms of my involvement in a wrongful conviction was Michael Morton's case. I was part of Michael's legal team and actually started working the case long before the big famous DNA fight. Started working the case in 2004. Throughout the time period that I worked on the case, obviously we saw a great evolution in terms of the issues that actually pointed to the cause of the wrongful conviction. At the end of the day, I think everybody who knows anything about the Michael Morton case knows that it was the DNA that ultimately led to the exoneration. But DNA was not the only issue. There were issues regarding prosecutorial misconduct and the failure to disclose Brady material. But something that you don't hear as much about, there were forensic science issues. Specifically, one of the main reasons why Michael was actually convicted in front of the jury back in 1987 involved evidence regarding the autopsy that had been done in the case. And so ultimately, at the time of the exoneration and all the work that took place after the exoneration, a lot was revealed in terms of the accuracy of the information that was put in front of the jury that led to the conviction. So at the end of the day, you look at the Michael Morton case and you certainly see prosecutorial misconduct, as I said. You see forensic science playing a role in it. And then, of course, DNA, which is another scientific issue. But at the time, we weren't in a state where we had the advances that we do now that would have led to being able to establish that the bloody bandana did not have DNA that belonged to Michael. Instead, it belonged to Mark Allen Norwood, who has since been convicted of killing Michael's wife, Christine. When you talk about Michael's case, I think it's really important to differentiate the roles of the prosecutors. What people hear the most of now is the trial prosecutor, whose name was Ken Anderson, who ultimately was held accountable for his actions in the case. The prosecutor that you're referring to is John Bradley, and John Bradley was actually the district attorney in Williamson County that was involved in the post-conviction fight, and that predominantly was a fight over whether or not that bandana should get tested pursuant to a Chapter 64 request for DNA testing. I can tell you my answer based on what I've heard John Bradley talk about publicly, but I can also give you some insight just in terms of knowing John. I worked with John on the opposite end of the aisle for over 20 years, and I think John, this is more of kind of the personal explanation, I think John absolutely believes in the finality of convictions, and I think that he felt that the DNA testing could essentially lead to challenges regarding the finality and where do you draw the line. I think probably he would have said in his own words that it was a slippery slope. And legally, one of the positions he took in regard to the bandana was he said that the bandana was not actually part of the crime scene. And since it was not part of the crime scene, he did not believe legally it fit the qualifications for Chapter 64 testing. So I've kind of blurred the two answers together. Personally, I think he strongly believes in the finality of decisions. But then what you heard him talk about publicly in regard to the case was the argument that the bandana was not within the realm of evidence that should be tested in regard to criminal convictions. So a couple of comments about that. I think if you talk to John Bradley today, he would say, you're right, I was wrong. We should have looked at it, we should have tested it, because what's the downside? Either you're going to find evidence that potentially exonerates, or you're going to find evidence that potentially says we got the right guy. So I think from today's viewpoint, he would agree with you. But as far as looking at legally his position at the time, I have to tell you, legally I don't even think he was right. The argument that the bandana was not part of the crime scene, I just have no idea where that came from, because if you actually look at documents from the original law enforcement investigative file, somebody, a deputy who had actually found the bandana, drew a sketch sketch of the crime scene. And when you look at that sketch of the crime scene, the bandana was found smack dab in the middle of it. So to make the argument that it wasn't part of the crime scene, just as I said, has always puzzled me at best. And let me be fair and clear when I talk about this. The sketch that I'm talking about is literally somebody, you can't really tell now because I didn't see the original, but somebody actually drawing a map and writing an investigative note in regard to what that map constituted. And it was really the area that they had actually patrolled and looked for evidence based on what they thought might have happened at the time Christine Morton was murdered.
So they don't they don't take photographs?
So you got to keep in mind the crime occurred back in 1986. So certainly there were photos of the crime scene, but you got to understand the photos that they had at the time were predominantly in the house where Christine's body was found. The crime scene that I'm describing is the area around the house, the perimeter around the house that they actually investigated, looking for evidence of either the ingress and egress of the person who did this or any physical evidence that might have been left or deposited in the area. And so the bandana was smack dab in the middle of that. That's a very, very difficult question. I don't know, because you have to understand when the Innocence Project was working the case post-conviction, as Michael would describe it, they always had a plan A and a plan B. And plan A was if there's any physical evidence that has DNA that can be tested, that's what we want to do. As Michael says, plan B is, well, what happens if either A, that there's not any DNA evidence, or B, the DNA evidence doesn't pan out? You got to look towards, are there other issues in the case? And plan B became known as the Brady part, the due process violations. And so if we completely take the bandana out and we look just at the Brady issues, I think that yes, we probably would have gotten to the same result that we are in today with Michael. I think it probably would have just taken a little bit longer, because I think what that would have done is it would have required the court to actually rule on whether or not the Brady violations rose. And I have to be careful about saying Brady violation, because when you're talking about it from a court's perspective, the fact that they're saying a Brady violation generally means that there's materiality and we're going to reverse on the due process grounds. So I want to be very clear. There was exculpatory information that was withheld. Ultimately, the court would have had to look at it to determine whether or not it was material and whether or not a reversal was warranted. I think that the information that was withheld in this case would rise to that level. And then once that happens, the court says, okay, the posture that puts Michael in is he goes back and he starts from square one, and the prosecutor's office then has to make a decision as to whether or not they would retry him. And so whether or not they would have retried him is probably, in my opinion, the most difficult question if you take the DNA out of the equation. If they decided that they would retry him, I'd like to believe that he would have been found not guilty. Hopefully, they would look at the case and they would say, now, because of what we know with the autopsy evidence, maybe they would have said, you know what, we're not going to retry him. But interestingly, if they had decided that, we probably wouldn't be in the boat where we are now, which is a legal finding of actual innocence. It may just be a wrongful conviction. So if you didn't have the bandana, you didn't have that aspect of the case, John Bradley most likely would still be the DA, and he would be the one making the call as to whether or not he got retried, assuming that the court said the Brady violation resulted in due process violations and you reverse. So, hard to say, because I think so much of what Bradley has learned from this comes from the DNA. So really, really hard to predict how he would have reacted if that wasn't part of the equation. And unless there's an agreement. I mean, sometimes you have situations where a prosecutor and a defense attorney will say, I've looked at this and we think that the Brady violation warrants a due process claim, which means they should get a new trial. So sometimes you have agreements that get sent up to the Court of Criminal Appeals. Court of Criminal Appeals still has to say whether or not legally that agreement is sound. But take the agreement out of the equation. If it's something that both sides are arguing about, obviously the court, once again, is the final arbiter. But what they do, if they ultimately say yes, due process violation, we're reversing, then it is an individual decision of the elected district attorney in that office to decide how do we go from here. And what you hope for is we've seen so much in the last decade in regard to wrongful convictions and the toll they take on not only the person that was wrongfully convicted, but the victim's family, the community in terms of how we look at the criminal justice system. We hope that what we've learned will cause elected DAs to pause and maybe make better decisions as we move forward. I think a lot of what we have to recognize is there has to be a bit of a cultural shift. And that cultural shift has to be that the paramount concern is not always going to be the finality of the decision. It's going to be doing what's right and looking at what justice means, now knowing that we are a system that has gotten it wrong far too often.